straight ahead on Law and Crime Daily.
It is a blatant attempt to kill George Floyd a second time.
A special hearing for the 4 former officers charged in the death of George Floyd. We break down important arguments filed in court.
And
2 deputies who were ambushed by a gunman in a cowardly fashion.
The search is on for the suspect accused of shooting 2 Los Angeles County deputies.
Plus,
when it all added up, I went, wow.
A jury delivers a nearly $100 million verdict after officials returned 2 children to the father suspected of making their mother disappear.
They cannot ignore this award. They're going to have to address the issues.
An exclusive interview with the children's grandparents who scored the victory is straight ahead on Law and Crime Daily, where we cover court cases from coast to coast. And welcome, everyone. I'm Aaron Keller, along with Brian Buckmeyer and Terry Austin. A Minneapolis judge must decide a series of key arguments that will have serious impacts on the trial of 4 former officers accused of playing a role in the alleged murder of George Floyd. The officers are arguing at this early point in the case that their actions were justified when they put Floyd into a police SUV after a nearby store owner accused Floyd of trying to pass fake cash. Floyd's friend said he was terrified after having been shot by the police in the past, and the struggle ended with all 4 officers holding Floyd to the ground. He died shortly later. Protesters gathered outside the courthouse, laying on the ground in honor of George Floyd. They want the trial to remain in the Twin Cities, not move to some faraway county.
We demand that these trials stay here, where they have to face the wrath of the communities they have terrorized. As for the upward sentencing guidelines called for by the prosecution, bring it on. Actual murdering cops should be actually prosecuted. The prosecution has a motion to try all these cases as one. The cops' lawyers are against it. They should all go to prison, together or separately, whatever it takes.
Legally, here's what the trial hearing was all about. The state is asking to join all 4 of the cases together into one proceeding to submit aggravating legal factors to the jury. Those can make the punishments more serious. And for the defense to disclose expert witnesses. The defense, meanwhile, is asking for a change of venue to move the case out of the Twin Cities, also asking to sequester the jury for the eventual trial, to disqualify the local county attorney's office, and to settle evidence issues involving character. This deals with evidence of so-called other bad acts and whether they will be allowed into the proceedings. Let's start with the topic of change of venue. Terry, I want you to listen to how an attorney for George Floyd's family argued against the officer's attempt to move the trial to another part of the state.
The only goal they have in trying to change venues is to get as many jurors as possible who do not look like George Floyd. They don't want jurors that look like you. No, they do not.
Okay, Terry, so the constitutional principle here is that every defendant has a right to a local jury of his peers. That's the defendant's right. The defendant can waive it. Can the state successfully force this trial to stay where the advocates want it to stay in the Twin Cities?
Well, here's what I think, Aaron. I think the officers want to move the trial out of Hennepin County because they're trying to say the pre-trial publicity is going to affect the trial. And in fact, we know there's a 6th Amendment right to a criminal defendant's right to a public trial in a county where it occurred. But the judge has already indicated that they should try to find a suitable jury in Hennepin County before considering changing the location. And actually, I think that makes a lot of sense because if you think about it, there's no way that you can get a jury who has not heard about this case.
You can't escape the publicity in this one. So, Brian, these defendants want separate trials, but the state wants to try everybody together because the process would be easier. Should the cases be split?
It depends on who you're asking. As a defense attorney, I wouldn't say want, I would say need. Especially if you're Tao, King, or Lane's defense attorneys, you need to separate these cases from Chauvin because Chauvin is probably the worst of the bad apples here, and you cannot try that case together with them. However, they're making very weak arguments to do that. They're not even trying to point the finger at each other by making an antagonistic defense. That would have been the golden egg for separation, but they're not doing it here.
Defense attorneys for ex-cop J. Alexander King are asking a judge to dismiss the charges, claiming George Floyd died of a drug overdose. The medical examiner said Floyd had fentanyl in his system and had recently taken methamphetamine. An attorney for Floyd's family pointed to the ME's listed manner of death, homicide.
There is no doubt that he died from mechanical asphyxiation. They want to coincidentally say that whatever drugs were in his system killed him at the same time that the knee on the neck and the pressure on his back killed him. And that's the falsity of this. So when you look at this from a legal perspective, the causation perspective, those drugs did nothing to him because we know that he had situational awareness. He was cooperative. He was begging to do what we all are doing as a matter of right, and that is breathing. He wanted an oxygen exchange between his brain and his lungs, and he was denied that when he asked, "Please, may I breathe?" That drug defense is desperate, it will fail, and it's false.
That will be disputed in this trial, it seems, based on the pretrial motions. Terry, another topic, though, I want to ask about. Some prosecutors have been disqualified for things like speaking to witnesses, such as the medical examiner. What's your reaction to that?
Well, you know, I think you have to be careful when you are prosecuting a case to make sure you don't have a conflict of interest by getting too involved. And here, I think the judge dismissed the prosecutors because they got involved. They went to the medical exam and the autopsy, and that was just too close for comfort.
They may be witnesses, may be disqualified. Brian, another topic here. So many topics in this pretrial hearing that we're covering. The judge ruled that George Floyd's record from Texas will not come in to the upcoming trials of the 4 officers. Now, that seems wise to me from a relevance perspective. Do you agree?
Absolutely. It's too abstract. Of course, whenever you have any case as a defense attorney, you want to try to create any kind of doubt or any kind of reason as to why the officers used force against the victim or the alleged victim in this case. But if you're going to go back to a different state years before any of these officers knew him or any kind of basis to understand what his background was, it's irrelevant, it's prejudicial, and it shouldn't come in.
And Terry, that core issue here of the actual cause and manner of death, why litigate that? I mean, I know that I guess you have to as a defense attorney. And Brian, you're shaking your head. Okay, so I'll go to you. Why litigate it? So many people saw the video. A lot of people would say, look, the drugs in the system, irrelevant.
It's not a matter of to litigate or not litigate. That's not why I'm shaking my head. It's don't litigate it now, because that is going to create a dead end at trial. Maybe you can spring it on the prosecutor. That's one of the best strengths that we as defense attorneys have. We can spring upon the reasonable doubt at trial. But if you do it this far in advance, that's out the window. It's gone as an argument.
Okay, Terry, do you agree? Is now the wrong time to do that?
This is what I think. I think that the medical report is going to be critical and that the witnesses at trial, the experts, are going to be key to this case because it all depends on what caused the death of George Floyd.
And still ahead here on Law and Crime Daily, a reward for the suspect accused of ambushing 2 Los Angeles County Sheriff's deputies. Has anybody seen? Two Los Angeles County Sheriff's deputies are out of surgery after being shot and critically injured in what authorities are calling an ambush. The Sheriff's Department is offering a $100,000 reward for information leading to the arrest of the suspect, seen here in surveillance video, which authorities say shows the shootings of 2 deputies sitting in a vehicle around 7 o'clock Saturday evening. Here's how the authorities described that suspect.
The suspect approached them from behind as the deputies were facing southbound in their patrol vehicle. Suspect came from the north. He walked along the passenger side of the car. He acted as if he was going to walk past the car, and then he made a left turn directly toward the car, raised a pistol, and fired several rounds inside of the vehicle, striking both of the sheriff's deputies. The suspect then fled on foot, northbound from the shooting scene and out of view. The deputies radioed for help. Assisting units from the district responded and transported both those deputies here to St. Francis Medical Center, where they're being treated. I can tell you at this point, we have a very, very generic suspect description of a dark-skinned male, and that came from one of the deputies, one of the victims.
The 2 deputies were rushed into surgery after radioing for help for themselves. The sheriff's office treated it. Protesters yelling, "We hope they die," outside the hospital, telling them not to block the entrance. The tweet has since been deleted.
Well, they're both suffering from multiple gunshot wounds. They're out of surgery right now, so we're going to keep them in our thoughts and prayers. One is a 31-year-old mother of a 6-year-old boy. Her husband is here with them. The other one is a 24-year-old, and parents are here. Girlfriend is here. They're both out of class 437, so they just graduated, and in fact, I swore them into office just 14 months ago. These are real people doing a tough job, and it just shows just the dangers of this job in the blink of an eye.
Terry and Brian back for some analysis now. Brian, let's assume this case goes to trial. It looks like prosecutors have an attempted first-degree murder charge because the suspect was allegedly lying in wait and committed a premeditated crime. And there's other reasons, like a special law in California that ups the charge, basically, if the victim is a peace officer.
Again, assuming this case goes to trial, because we have to find the suspect and he has to make it to court. So assuming those two parts happen, this person is looking at a monster of a hill of trial against him. This is not something the prosecutor is going to offer a deal to. They're going to be asking for the highest punishment of life, because this, I'm all for protesting. I'm all for good trouble, as John Lewis called it, but this is not it, and this is disgusting.
I think just about everybody agrees with that. Terry, I think you agree as well. Got another question, though, Terry. These people outside the hospital are basically saying they want the officers to die. Could those people potentially be charged if we're taking a bar exam look at things, I guess?
Well, they have the right to say that, although obviously it's a horrible thing to wish that upon anyone. But they don't have a right to block the entrance or to obstruct the police or not to obey the police. And as in fact, they can be charged with obstruction or resisting arrest. There's even a charge called contempt of police officer for not obeying the police officer. So you can get in trouble for that.
And Brian, real quick, I think you were thinking potential disorderly conduct as well.
Yeah, if you want to get really creative, you can get disorderly conduct. You can stretch it. I don't think it would stick, but maybe also reckless endangerment, because people need to get in and out of that area for life-saving surgeries.
And coming up next right here on Law and Crime Daily.
He always complained and he always ranted and always broke the rules.
So why did authorities give such a father a visitation which led to the murder of his 2 children? And now to a record judgment against the Washington State Department of Social and Health Services for returning 2 boys to a father suspected by many of playing a role in the death of their mother. Susan Powell disappeared in December 2009. Her husband, Josh, claimed he took their 2 children on a midnight camping trip in sub-zero temperatures when Susan disappeared, and he maintained his innocence in her disappearance. In 2012, Josh locked a social services worker out of his home during a supervised visit, killed his children with a hatchet, and killed himself by setting fire to the home. The grandparents of those children sued the Department of Social Services and won $98 million. They recently opened up to me about the case and the verdict.
The main thing I heard was the verdict that they were guilty of negligence. That was the important part. And then the number was, they didn't say 98 million, they said 45 million or something, which I thought, but that was as they were breaking it down. So I thought, well, that doesn't very much. But then when it all added up, I went, wow, they cannot ignore this award. They can't just, pay it out of petty cash or something and be done with it. They're going to have to address the issues.
And that's ultimately the hope here, is that the state will really look into this and try to prevent this from happening to any other family.
Yeah, absolutely. As we went through the entire trial, their witnesses for the state, which was their employees, they admitted all throughout that they did not follow the proper policy guidelines for dealing with domestic violence and dealing with the situation. And I could not believe that they thought they were somewhere making progress in the case, but they went on through, and it was clear the amount of negligence, the amount of incompetence at all levels of supervisors on up in DSHS was clearly made, presented to the jury and to the world.
During that trial, attorneys for those grandparents asked for $5 million for each minute each of those children suffered.
Unfortunately, the only way that we can render justice in a situation like this is through the awarding of money. Money damages are the only choice. And so I put it to you this way. We consider what the obligations of the state were. We consider what options they had available. We consider what they recognized the risks to be. We consider what they actually did. And we consider the result. This incredible, miserable end.
The state argued unsuccessfully that its caseworkers had done enough.
It's very difficult to show potential risk in these situations where you might think something is going to happen, but you don't have enough proof to remove a child. It actually takes facts and proof to remove a child from their parent, to keep them out of the home. You can feel like there is risk, or you can sense there is risk, but gut feelings don't count. Charlie and Brayden, and really specifically Charlie, continued to press, I want to go home to my father. It was evident that those boys loved their father.
And when we come back, more from the parents of crime victim Susan Powell, why they took the step of suing the state, and why the law was ultimately on their side. That's when we return on Law and Crime Daily. We're back with more from the parents of Susan Powell, whose husband was suspected of killing her and who later killed himself and the couple's children. Susan's parents, Charles and Judy Cox, told me recently about why they chose the long and difficult path of litigation.
Genuinely, originally thought, well, these were civil servants, overworked and underpaid and whatever, with limited resources. But then when we found out that they had basically plotted and conspired to get the children back with Josh, they basically were negligent of doing the job that they were paid to do, child protective services. They weren't protecting the children. I felt this has to stop, and this has to be, we have to do something to expose the negligence and the lack of knowledge of the people in charge. For them to say that's not domestic violence when you are the only suspect in your wife's disappearance and award custody through killing your spouse or getting rid of your spouse is just ludicrous. It makes absolutely no sense at all. And these are supposed to be people with psychologists and social workers training and understand domestic violence and dealing with difficult people and all like that. And we were let down completely.
The Powell's attorneys told me they expect the full $98 million award to come out of the state's coffers. The jury determined that the state breached its duty to protect the Powell children, an open and shut negligence case.
We believe that this is an absolutely unassailable number. The evidence supports the number. The state did not argue against the damage calculation or suggestions that were made at trial.
And we don't have caps in Washington in cases like this. So we don't have, like you see in California, other jurisdictions where there'd be certain caps, like medical malpractice cases, et cetera. We don't have that in Washington state. We don't have punitive damages in this state. So this award was based upon conscious pain and suffering and damages of those kids.
The jurors found that they suffered greatly for a great amount of time, and that is very painful to think about. Obviously, it's excruciating to think about. But on the other hand, that the jurors recognized that pain and decided that the state was responsible for that pain was also gratifying, because we hope that it gets a note across that they need to follow their protocols so this kind of pain and suffering doesn't happen again.
Charles and Judy Cox say they plan to earmark their record verdict towards advocacy, including legal assistance and housing assistance for women like their daughter who had to leave abusive relationships.
It's not over yet, but the jury verdict was very comforting and a clear vindication of our stand and what we found and proved that we did prove in a court of law that they were negligent.
And tomorrow on Law and Crime Daily, Charles and Judy share their thoughts on exactly what happened to their daughter and who else might have been involved. Terry, you worked in a government law department. How might agencies be handling that type of verdict?
Not very well, Aaron, but let's hope this is a wake-up call for the agency to make changes so we won't see this kind of incident happen again.
And in some states, Brian, there's a cap on damage awards like that. So in some states, a jury might say $98 million, and the plaintiffs might get just a tiny fraction of that.
Exactly. It's going to be interesting to see how this plays out. Again, we're hearing their lawyers talk about how that's going to be distributed. And I think the family has a great idea as to how that money can help people in the greater community.
Certainly. Great analysis here on Law and Crime Daily from both of our experts. We appreciate you joining us. Thanks for being here along with us for everything. We'll see you right here tomorrow for our coverage of the day in court on Law and Crime Daily.